everybody. Happy New Year. Welcome to the first Friday with Fran of 2024. Thanks for coming out. It's good to see everyone. Hope everyone had a happy New Year, safe New Year. And I hope we don't get too much crazy snow and ice tomorrow, right? I think we're supposed to get some tomorrow. For all those who are the snow captains, God bless you. So you'll be up all night on Saturday night. But hopefully we won't get too much snow and ice. So again, Fran McGovern Legal Services, here with Mike Palulak from my office, as well as Crystal's with us too, helping us out. So today we're going to talk about a legislative expands power to issue temporary and final protective orders. We'll talk about that a little bit and why it's important to us, why we care. But preliminarily, we're going to say Happy New Year again. We're going to have Dog of the Day. Crystal, if you don't mind putting them up there. We actually have dogs of the day today. We're getting these multiple dogs, sneaking them in. This one we got 3 dogs, and this is Jeff Schiffman, who is a regional supervisor over at Taylor Management. Jeff submitted them. Like those dogs a lot, especially like the one in the middle. So that's from left to right. That's Bailey, Kobe, and Pebbles. So Jeff, thanks so much. I don't know if you're out there, Jeff. I haven't seen you yet, but thanks for submitting the dogs of the day. And everyone else, please keep us in mind for dogs of the day if you have not submitted your dog. And make sure, if anyone has not gotten their 2024 calendars, we still have 2024 calendars left. So if you email us your contact information, we will mail you a calendar. And yes, they are free. People have asked me, hey, friend, do I got to pay for the calendar? No, the calendars are free. In fact, we are prohibited from selling them. They don't allow us to sell them because that would be a law firm engaging in another form of business, believe it or not, which is so strange. But anyway, weird stuff when you're a lawyer. So that's Dog of the Day. Now, here's something we talked about last month. We didn't have much of an answer last month, and we have a little bit more of an answer this month. Not so clear what's going on with this, but it's the update on last December's mulch discussion when there was the new regulation. I'm going to flip to it, that prohibited the use of combustible landscape materials such as wood-based mulch products within 18 inches of any building or structure. So the issue there was, hey, if the code is being amended to prevent you from using wood mulch products or other flammable materials within 18 inches of a flammable structure, does that mean single-family homes? Does that mean single-family homes? Mike reached out to Dan Timmerman over at the Fire Code Subspecialist's office in the State Fire Marshal's office and the Division of Fire Safety. And Mike, do you want to jump in there?
Yeah, so there was a little bit of confusion as to really what it pertained to. And at the beginning of all of the regulations, there's a statement which indicates that it excludes single family and multiple. Frank, do you have the language in front of you?
Yeah, I'll quote. Yeah, Mike, I'll quote the language.
You want to quote the language?
It says, the Uniform Fire Safety Act requires that the proposed amendments, repeal, and new rule must be uniformly applied to all premises other than owner-occupied 1- and 2-family or attached single-family dwellings used exclusively for dwelling purposes. So Mr. Timmerman basically said, no, it doesn't apply to your single-family home communities with respect to the mulch around their homes. The language, though, that Mike was describing under the regulatory flexibility statement is super, super unclear. Mr. Timmerman himself said it very well probably applies to your clubhouses. Okay, that's one. And the language itself is so unclear because the language suggests that it may not apply to townhouses, but I would not put money on it at this point. So there's going to be some shakeout in this regulation. And as I said in December, before you do any huge mulch project, please check with your local fire official, right? Because this language is so poor that I don't want someone to go out and go into contract for a huge mulch replacement contract, especially if you're not single family homes, if you're attached, semi-attached, what have you, and be stuck and find up find yourselves redoing it or trying to break your way out of a contract because of frustration of purpose under the law. So it looks like I said, it looks pretty safe. Again, my caveats always apply. This is not legal advice. Check with your own attorney. This is not an attorney-client relationship. I didn't read all 4 caveats today. We won't keep anything confidential. To go out and have an attorney relationship, you got to go sign a fee letter with an attorney. But generally speaking, you should check with your attorney. And I think if you're going to do a big mulch project, first check with your local fire official. I'm not saying that if you're not doing a mulch project, you should run out today or tomorrow or Monday and call your fire official and say, hey, we have mulch everywhere. Should we remove it? So I'm not suggesting you open up a can of worms and invite inspectors all over the place. I'm suggesting you do that before you get into a contract for a large mulch replacement project, okay? Because I don't want you to get jammed up. That makes sense? Does kind of make sense to everybody? You know, I don't know who the lawyers are that write these regulations, but I should be sending them Christmas baskets because they create more and more work for us, right? Because they write language that it takes us hours and hours to figure out what does this mean. And you know, like they say about legislation, it's like a sausage factory, and I believe them. They have convinced me. So there you go. That's the update on mulch. Like I said, looks like there is a measure of safety with respect to single-family owner-occupied homes, which makes, I think many of you, if not most of you, a lot more comfortable than we were in December. So what else do we have? Temporary and final protective orders historically. Let's talk about temporary and final protective orders. So historically, associations would try and get protective orders. Why would we be in the business of trying to get protective orders or telling our employees or our residents to get protective orders? The reason we would is because people were, for example, harassing our managers, harassing our board members, harassing our supers, harassing each other. We've had issues. I've sued board members of associations that I actually represent, which is kind of crazy. And I still represent them, believe it or not, even after suing that board member. But so, as you know, in today's world, there are a lot of people who cannot control themselves. And historically, though, courts were either refusing to issue restraining orders, protective orders, or just not even wanting to hear the case. I've even had a case in, I think it was Ocean County, where the judge said, Fran, I don't even want to see you on the return date of the application. And I may shift attorney fees against you because, Fran, you should know better than anyone else that the court generally only issues these orders in really 2 circumstances. One, if there was a family relationship going on, so it didn't have to be actual marriage, but it would typically be instances of marriage, domestic violence type situations, divorce situations, families that people who live together, whether they're married or not, you know, partners, if you will, and or parents of children, whether or not they had been married or not. So that's the kind of domestic violence kind of situation. And that basically grew out of people who were partners, former partners, even cases, the courts would stretch it sometimes, even to former roommates. Basically, the courts would issue protective orders if there had been a prior relationship and the people were harassing each other or not leaving each other alone, okay, despite requests. And you've seen this in the newspaper, the police coming out, et cetera, et cetera. The other situation where courts were willing to issue protective orders was sexual assault cases. So even though the parties didn't know each other, if there was a victim of sexual assault or improper sexual conduct, et cetera, the courts were willing to issue restraining orders even though the parties didn't know each other. So the courts would say, hey, you know, this guy won't leave you alone. I know you don't know him. I know you've never been involved with him, but I'm going to issue a protective order that he has to leave you alone. And if he doesn't leave you alone, he's going to get really jammed up on a contempt case. So those were the 2 situations where the courts were pretty willing to issue protective orders, whether temporary or final. We, up to this point, would go into court because at many times when we had a situation where an employee was being harassed by a member, or even in cases with member on member, or even an employee on a member, the courts would decline to issue the restraining orders, temporary restraining orders or not. Uh, the good news about what we have now in the new legislation, which was passed, I believe, in July, and I think it became effective as the 1st of January, is that the protective orders were broadened, right? Very much broadened. So what the old act was called was the Sexual Assault Survivor Protection Act, right? As well as the Domestic Violence Act. So that's the two issues we talked about historically, Domestic Violence Act and the Sexual Assault Survivor Protection Act. The Sexual Assault Survivor Protection Act has been renamed the Victims Assistance and Survivor Protection Act. So it's taken out those requirements, even though it still does address sexual violence, etc. It's taken out those limitations and allowed people who, whether or not they were in domestic relationships and whether or not they were victims of sexual assault, to get protective orders based on stalking or cyber harassment. Stalking or cyber harassment. Okay. Now, I'm not trying to have the people on the call invite them to go out running around and every time you hear someone say, they are harassing me, that you should rush to court and say, we need a protective order because the judges are going to say, get out of my courtroom. But if there is a legitimate basis for it, the association may have to get involved because in most association governing documents, there is a duty to provide safety within the community. There's a duty to prohibit nuisances. There's also a third duty to provide ADR between parties that are harassing each other, perhaps. And under the Fair Housing Act, there are strict prohibitions that impose a duty on the association to stop certain discrimination within the housing context. So you're all familiar with this, like you've heard me talk about it many times. No discrimination based on race, creed, color, national origin, sexual orientation, trans status, etc. Right? So all those wacky types of discrimination that do happen on occasion in housing, the association has an obligation to take steps. So the good news is, and I think this is a good thing, that if the association has to and can provide a basis for it, if the association can show stalking or cyber harassment, the association may, and or its employees and or its members, may be able to get protective orders, whether the temporary protective orders or final protective orders, based on stalking or cyber harassment. Now, when we talk about stalking, the way this new section describes stalking is, and I'll read it. As you know, I don't like reading, but reading, I like to speak extemporaneously. I don't like to read to you guys. But a person is guilty of stalking, a crime of the 4th degree, if he purposely or knowingly engages in a course of conduct directed at a specific person that would cause a reasonable person to fear for his safety or the safety of a third person or suffer other emotional distress. I mean, that sounds really, really broad, right? Really broad, which is good in a way, but it's bad in a way. Sometimes we get complaints that says, people will say, he scares me. Why does he scare you? Well, he's 6'6", he weighs 250, and he's got sleeve tattoos. Okay. What did he do to you? Nothing. What was he doing? He was walking through the clubhouse. He's got a tattoo on his neck. Okay, he hasn't, no, that's not going to do it. The fact that you, for some reason, are uncomfortable with that doesn't mean it rises to the level of stalking or harassing. So you have to be careful from the associations or the board's perspective. Obviously, you want to look at those issues, right? If someone brings it to the attention of management or the board, if someone says, hey, I'm scared, she's scaring me, I think there's a problem with her, she's scaring me, or he's scaring me, there's a problem. But you cannot just run to court and say, therefore, I'm entitled to a protective order against that person. So again, I'll read it again. A person is guilty of stalking, a crime of the 4th degree, if he purposefully or knowingly engages in a course of conduct, right? Not just standing there, course of conduct directed at a specific person that would cause a reasonable person to fear for their safety or the safety of a third person or suffer other emotional defense. Some people say, hey, Fran, what do they mean by the safety of a third person? That often is family members, right? So I'm concerned that that person who I feel is threatening me also is a threat to my family. So we've had instances where parents, for example, were concerned about sending their children to the school bus stop because there were gentlemen living next door that they felt there was a problem with, and they did not feel that their children were safe at the bus stop. So these are issues that may come up. The good news is if there really is a problem, the association can act and the court may be willing to institute a temporary protective order. Keep in mind, however, especially when you get involved with children and so forth, um, having a protective order is a piece of paper, right? Everyone knows this who's watched 48 Hours, right? Everyone says, and then she got a restraining order against Kenny, the bad guy, right? And then 2 days later, unfortunately, she's dead, right? Keep in mind that a protective order is just a piece of paper. So even though you take those steps and you go to lengths to protect yourself, there are more often than not additional steps that you may have to take to protect the people within your community, whether that's lighting or security or cutting back hedges, alerting the guardhouse if you have a guardhouse of certain people that perhaps should not be permitted on site, things like that. So keep in mind that protective orders are wonderful things in terms of a step, but they're just a piece of paper in terms of the real world. Okay, does that make sense? You hate to see that. I mean, my wife watches 48 Hours all the time, and I repeatedly see, there was a restraining order in place against the bad guy, and then the bad guy went out and did bad stuff. Okay. So the other thing that it protects is cyber harassment, which is a little more challenging for us, right? Because how many people in the association have had postings on websites related to the association, not the association's website, but related to the association, that says all of the board members are boobs. They have no idea what they're doing. They're bankrupting the association. I hate management, and their lawyers are even worse. Right? Right? Everyone has had those kinds of postings, right? So that would generally not be a crime of cyber harassment because, again, when you get into harassment in terms of cyber harassment, you also are starting to touch on what? Speech, free speech, right? And I'm not going to get into what's been going on for the past since October, right? Because free speech has been a crazy thing in the media, and people are losing their positions over that, whether it's right or wrong, I don't know. But you got to be careful with free speech. So someone's going on to a website talking about the association or the quasi-public figures who are the board members saying things that may not thrill you doesn't necessarily rise to the level of cyber harassment. So oftentimes we get emails and calls from our board members saying, hey, Mary Jane is really mean. She is really mean to the board members. She's really nasty. She says bad things about the board members. She say we don't know anything about the financial affairs of the community, and we should all be removed from the board. I say, okay, why does that surprise you? You signed up for this, right? Thank God you signed up for this. And they say, yeah, but she's abusive and we don't like her. Well, we're not going to go to court over that. So I'll talk a little bit about what cybercrime and cybercrime for those. This is kind of outside the association context, but the cybercrime reg amendment is also more, I would say, more focused on children. Not so much in the association context, of course, but in the context of other online activity. So, okay, a person commits the crime of cyber harassment if, while making one or more communications in an online capacity via any electronic device or through a social networking site, and with the purpose to harass another, the person threatens to inflict injury or physical harm to any person or the property of a person, right? So somebody posts, if I ever see you outside alone, I'm going to get you. That's a problem, right? That's a problem. And we have had board members threatened that way. I can tell you in our firm, we've had board members threatened that way. knowingly sends, posts, comments, requests, suggests, or proposes any lewd, indecent, or obscene material to or about a person with the intent to emotionally harm a reasonable person or place a reasonable person in fear of physical or emotional harm of his person. So where does that get crazy? And I haven't seen this in the association context. I have a friend who's a superintendent of schools, not around here, but he had a Facebook page that was related to his school activities, and somehow somebody hacked it and took all of his pictures. I don't know how any of this stuff works, and posted what are they called? I guess you would call sex toys, if you will, on his pictures that were online, right? So he wound up having, to mock him, to harass him, to whatever. And he wound up having to take his social media accounts down because they were basically harassing him with that method. And they were posting lewd things over his pictures of him that he had up there with students and so forth. So you may see that in the association context. I have not seen it in the association context yet, but I'm sure it's coming, right? We know that if it's out there, somebody in an association will do it, right? That's why our jobs are endlessly interesting and never boring, right? So that's awesome that we can prevent that kind of stuff, because in the past, if somebody came to us and said, hey, this guy, somehow he got a hold of a naked picture of me. It was from my boyfriend back in the 70s, and we were just having fun with Polaroids. And he somehow got a hold of it and posted it on the internet. Friend, make him take it down. I think under this statute, you can make that happen, right? Prior to this, maybe not. Prior to this, maybe not. So that's a helpful thing. And or threatens to commit any crime against the person or the person's property. So the person says, I'm going to steal your car. I'm going to mess up. If you ever park there again, I'm going to key your car, right? I'm going to wreck your car, right? So in many adult communities, you know this already. There are a lot of disputes that arise out of people parking in the street behind their neighbor across the street's driveway, right? Because then they got to turn their head really dramatically to get out of the driveway because it's difficult. And they say, you got to move your car. And if you don't move your car, I'm going to do something to you. That's a problem. So, basically, cyber harassment involves threats of injuries, posting things that are lewd, either requesting or posting things that are lewd, indecent, or obscene about the person with the intent to harm them, right? The problem with things like lewd, indecent, and obscene is many courts have a hard time defining that, including the United States Supreme Court, right? I think the United States Supreme Court, in one of their opinions, said, the definition of pornography is you know it when you see it, right? How do you define pornography? Pornography to one person may be something very different, pornography to another person. But like I said, in my mind, this is a helpful thing for association. It gives us another tool that helps us, especially in the extreme cases, stop certain conduct, such as cyber harassment and such as stalking. That, again, as a last resort, you don't want your attorneys running to court. And it also gives you a tool that even if the association is not going to run to court, the association may be able to suggest options as part of the ADR process, as part of the enforcement process within the community. So that's kind of a quick take on it. We do have some questions. I see some questions out there. If you want a calendar, please see the email. That's true. Yes, the calendars all are available. Who can we write to make suggestions before they?
Fran, I just looked it up actually while
Oh,
we're
did you? Go
talking.
ahead, Mike. Have at it.
Yeah, so it's not easy to find, of course, but it's under the New Jersey Department of Community Affairs and Division of Fire Safety. So I'll give you the email address here. I'll post it in the, it's for Tamika Dean at the dca.newjersey.gov. I just popped it into the chat there. That seems to be the person who you would contact. As far as we can tell, the regulations have not gone into effect yet. They're still out there. They're proposed.
Right.
The most recent updates to the regulations were December 18th, and these are not included in those. And quite frankly, the DCA, when they come out with new regulations, it's really frustrating. They don't make an announcement. It just quietly becomes part of the regulations, and then it's up to everybody else to figure it out. So it doesn't look like it's passed as of yet, but you can contact that person and certainly let her know your opinion on it if you would like.
Yeah. So what had happened is the reg was more or less put out there to the public. They had a public comment period, and the public comment period, my understanding, has closed. But that should not discourage you from sending comments in if you'd like to. Shouldn't discourage you. But the comment period, my understanding, is closed. And what the DCA intends to do is once it's formally adopted, which Mike is correct, my understanding it still has not been, they're going to give a year for implementation from the time it's adopted. That will give a year from an enforcement standpoint. So, given the language, we don't know um, how crazy they'll be with an enforcement. We don't know. I don't expect people running around your clubhouse and inspecting it, but it's possible. We'll see. If we hear anything else, we'll let you know. Find the statute for the new fire safety code. This is definitely passed, correct? Again, it's I would say 99% it will be adopted. So it's a regulatory body, so it's not so much a statute. We have mulching, our landscaping contract already signed for 2024. So Marge, the question there is it a single family home contract or is it a condo contract? That'll make a difference. If you get jammed up, there's always a frustration of purpose argument, right? Did the law change and therefore frustrate your contract? But what I would be doing, especially right now, since nobody's putting mulch out yet, is make sure you talk to your vendor now and perhaps even talk to the fire official. You do not want to wait until your landscaping vendor goes out and buys 10 tons of mulch, right? Because then he's going to say, well, wait a second. If you had told me back in January that there was a problem, I would never have bought all this mulch. Now I bought 10 tons of mulch and I'm stuck with it. I got a mountain of mulch in my yard and you got to take it because I'm stuck with it. So that's just, I would try and move on that now if you feel like you've already get included in a contract. I heard about a federal corporate transparency act that would sweep HOAs into some very onerous reporting. Is there something that we need to be concerned about? So Anna, I can make that the topic for next month. There is a Corporate Transparency Act at issue out there. I don't feel it's as onerous as people are saying. There are people saying, oh my gosh, this is terrible. It's the worst thing that's ever happened. More or less, it basically, as far as I can tell, I don't have it in front of me, was that each year, the association, in theory, right? Because as far as I know at the moment, associations haven't been excluded from this, even though I don't think it had any intention of capturing associations in its net. I'd have to look at it again, Anna, and see if there's an exception, but I don't think so right now. And what it requires is that the corporations report their principals on an annual basis. So I think people are interpreting it right now as requiring the board members, if you will, to be reported to, I believe it's the state on an annual basis. I don't know, and again, maybe I'll add this as a topic for next month, but I don't know how I think about that, whether that's really bad or really good. From a privacy standpoint, I think it's a little dicey. From a context standpoint, in some way for the lawyers, it's better. The reason I say that is many associations, their initial recordings with the state have never been changed, and the contact information is still the developer's attorney, believe it or not, sometimes decades later. So filing notices go out to a non-existent developer somewhere, and then eventually the association somehow gets a fine letter, and they say, we've never heard of you. Who are you? Why are you sending this to me now? And by the way, why didn't you send it to me directly a year and a half ago? And they say, well, we've been sending it to blah, blah, blah Development Inc. down in Manalapan. You're like, okay, I don't, right? So, so in some ways it's good. It's in some ways it's good for the lawyers. But here's the kind of bad thing, I guess. And it's not an awful thing for me as a vendor, but I would say that if all board members are required to register next year, who would love to see that list? every service provider to associations, right? So I can assure you, someone's going to be driving to Trenton on January 2nd next year, downloading that list and sending out blasts of marketing materials to every board member out there. So I can see how board members might feel that's not very advantageous for them to be inundated by vendor information. Let's see. Marge Wilson, I told the landscaper and he knew nothing about this proposed rule. This proposed rule. That's right. So Marge, I think many landscapers would not be in tune with this yet. And as Mike said, it's not really been formally adopted yet. I think it's pretty unanimous though that it's going to happen. I think it's just a matter of when. And it would be really nice for all of us, right, who have to deal with this every day, if they clarified that wacky exception language, because the language is really bad, really bad. Let's see what we got. Our streets are private. We have a resident who drives around endlessly looking into open garages, staring into backyards, observing groups of people. Talking, is this stalking under the new law? In the past, we avoided doing anything concerned. He would accuse the board of harassing him. So I guess that's Bill. So the way the statute is written, it applies to a specific person. It has to be a focus on a specific person. That's the way the statute's written right now. So I think if the person is just a nudge, right? Just a nudge who drives around and is a snoop and wants to know, what kind of car you have in your garage and who's having a barbecue and who's not and why I wasn't invited and why aren't people nice to me? And it's because you're a nudge. If you would leave people alone, they would invite you to the stupid barbecue, you nudge. But I don't think under this one, I don't think that what you've described, at least, Bill, right now would rise to the level of stalking under this amendment. Certainly if it was focused on an individual, right? Certainly if it was focused on an individual, I think it would. So that's it. It's 4:37. That was a quick one today. If anyone has anything else, let me know. Otherwise, I'm going to wish you luck out there in the snow and ice. Be really careful. Hopefully the weather will be nice for us and you won't all blow your budgets on snow and salt removal kind of stuff. But otherwise, I will see you next month, and I will make the topic, unless anyone objects, the corporate reporting requirement. Okay? Great to see you. Nice to see everyone. Happy
care,
New Year
everyone.
again. See you soon.